Call a meeting of the fiscal court to order. Good to see everybody here this morning. Fall is almost upon us. We have, before we get into our meeting this morning, one of our own has received a very prestigious award as the Emergency Management EM Director of the Year. Melissa Combs has served us as our Emergency Management Director for a number of years, and she has been awarded, I'll just read this, the Excellence Award awarded to Melissa Combs in grateful appreciation and distinguished recognition of your hard work, devotion, and commitment to excellence. EM Director of the Year, 2013. Where is Melissa? Melissa? Congratulations.
Thank you, sir.
Melissa is no longer Melissa Combs. She is recently married. Got married in Tulu, Kentucky. That's my first trip to Tulu. Yeah, Dwayne and I made the trip. We appreciate Melissa and all the work she's done. Thank you. We have some guests that are asked to appear before the court this morning. Mr. Denny Knoll. Denny, you're up.
Judge, can I just come up here and sit?
That'll be fine.
I've got a letter that we were just gonna send in, but I'd just like to just go ahead and read it in, and then I'll give it to the court, if that's okay. Please be advised that I represent Marshall County Refuge Board and recently attended the Marshall County Fiscal Court meeting on August 13, 2013. At that meeting, the fiscal court, through their attorney, Honorable Jeff Edwards, read into the record a special report that made certain findings related to Judge Miller. Also contained in that report was a reference to groundless allegations of misconduct related to activities by the Refuge Board. The members of the Refuge Board want to make it clear that they are deeply disturbed that these unfounded allegations continue to be discussed and asserted against them. To this point, the Refuge Board would note and want to make a public record that at the behest of certain members of the fiscal court beginning in August of 2012, a full investigation was conducted by the Attorney General's Office of Commonwealth of Kentucky. In sum, the Attorney General's Office issued a report that consisted of 16 pages based on numerous interviews and document reviews and made a finding that the Refuge Board had committed no criminal violation or any wrongdoing in executing their duties. Apparently, subsequent to this clear finding of no misconduct, certain members of the fiscal court continue to make baseless allegations related to the Refuge Board. Some of these allegations do not even merit a proper response. However, based upon their inclusion in the reading of the August 13, 2013 special report, we felt it necessary to set the record straight and let the public know that the Refuge Board operates to the best of their ability and within the confines of all applicable laws. We sincerely hope that this ends this issue between certain members of the fiscal court and the Refuge Board, so as the fiscal court can continue to appropriate business on behalf of Marshall County. Thank you most sincerely. Did it so much. That's all I have.
Thank you.
Dennis, I'd like to respond to that. Originally, if you all will recall, the question was whether or not there was a criminal element to that, but the main question was whether or not the board members had violated their duties according to their obligations as being board members. That was my original and remains to be my concern, which is why I had asked for the actions of the board members to be looked at, not just from a criminal element, but whether or not they met their duties as being board members, specifically related to their financial obligations to the taxpayers. And I think the record is very clear that in paying a private businessman actually it was about $100,000, I guess, more, as well as the treasurer and some of the other funds that they were allocating at that time, we're saving $100,000 because of the questions that were asked each and every year, and that's a savings to the taxpayer. And I think that the Refuge Board members should answer as to why they made those decisions to pay private businessmen $2,000 a month for a service that we're now paying, I think, what is it, $2,000 a year for? Those are the questions that I think needed to be asked, and those were the questions that I wanted each of them to be present for, to be answered, not only by us and asked by us, but by members of the community. We're saving a lot of money because all those questions were asked, and whether or not anyone was charged with a crime, and I appreciate the investigation, to that extent, but I still have concerns as to why all that money was being spent. We didn't have a contract with anyone. You're an attorney. If you're going to pay somebody $2,000 a month, that you have to have a contract. And I'm sorry, but a handshake agreement does not stand up today. So those were the reasons why those things were questioned. And I think it's logical questioning, and I would question it again today if it were still existing. Thankfully, they stopped doing it when all the questions arose, and I appreciate that, but it doesn't mean that it was right to begin with.
Well, that's not exactly accurate, because the issue had already been addressed prior to the investigation. You just raised the issue of the contract. Well, they had a verbal contract. Verbal contracts can be binding. There's no reason that contract couldn't be binding. And again, that issue was completely addressed by the Attorney General's office. And again, there was no finding of any misconduct or any kind of dereliction of duties or anything of that regard. Now, I will say that, there are allegations, and I'm not going to get into them specifically here today, but there's allegations beyond what you just addressed there that are, just crazy, silly allegations that have been made to members of the general public that weren't part of that report, that weren't part of the investigation, and that's really kind of where we're going and what we're concerned about. And if you recall back in I guess it was back in August of 2012 when I was at one of these meetings, I asked, and I think I asked you directly, you mentioned that there's multiple allegations, and we were aware of the one that you just addressed there, but I wanted to know what these other allegations might be, and we never got an answer to it, and those didn't seem to be submitted to the Attorney General's office. But what's happened after the fact is now we're starting to hear some of these, like I said, just wild allegations being made, and if somebody wants to step forward and put their name to them, they can do it.
I can't answer to wild allegations, and I completely understand if those are being made, why you would be concerned, but I can tell you that my concerns were among the one that I mentioned. Why we would be paying the former road department superintendent an additional almost $30,000 a year to serve as a consultant. The taxpayers were already paying that person to be a road department superintendent. I know Russell doesn't get an extra $30,000 a year to come over and attend a meeting once a month. Those types of things are absolutely inappropriate, and as board members, they should have put a stop to that. And so when we went through and we held members of the North Marshall Water Board accountable, and I'm sure everybody remembers that. Everybody likes to mention, well, why didn't you all do anything about North Marshall? Well, we did. That's a totally different board serving, and in my opinion, you should have a totally different board serving at your refuse as well. And those are just a couple of things. We were also paying our county treasurer an additional $17,000 or so a year. Emily, you're not getting that. All that money should have never been paid out. And as board members, they should have been responsible to make sure that those costs were looked at more closely. And so that was my concern, and it still is.
Mr. Null, I started this years ago, and I went to the board and talked to them individually. There was no one listening. No public was present, and because I thought that was the appropriate way to deal with it. And I did this a number of times, and I tried to not embarrass anyone, because I'm looking at faces right now that have been lifelong friends of mine, and I don't like any of this. I'd rather not have done this. I'd rather the public not known it. I'd rather us fixed it quietly. But I couldn't get it. I couldn't accomplish that. No one would hear me. So I went to our county attorney and asked him to accompany me, which he did twice. And he told them in my presence that what they were doing was a crime. They had to stop now.
Well, again, what you're referring to, Lisa Evans with the Transportation Cabinet advised them that, in the way that they should be handling that issue. And again,
That's
there was
not
no
my
finding.
point. That's not my point. This is a mute situation now. It's just come and gone. What I'm trying to point out to you is, and to those board members, is I tried my very best to do this quietly. I didn't want this to be make a public spectacle of anyone. And if they'll look back, they'll find out I'm not the person who called the TV station and the media. I went to the county attorney and the county attorney accompanied me to their meeting, and no one was present but the board members and the county attorney and I. And we discussed that with those guys. I didn't want to embarrass anybody. I just wanted them to stop because I thought it was a poor practice. I still think it was a poor practice because we right now these taxpayers are receiving the very same service, exactly the same service for $2,400 a year, which we were paying well over $100,000 for. Exactly. Now, if that's not my responsibility as a commissioner to address those issues, then I need to go home. We just need to quit. I don't know what we're supposed to do. When I see something that's that kind of a contrast, I think that's my job.
Well, I mean, again, we've got a difference of opinion on some of the factual history of it, but, you know, we're hoping this is a.
Well, the factual history is the proof's in the pudding. The proof's in the pudding. Anybody in this room that wants to go downstairs and look can see that what we pay now for those services, and they are getting exactly the same. Plus, we're not subsidizing them any longer.
The proof's
So
in
it's
the pudding
probably
in the
$300,000 or $400,000 difference.
That's criminal, though. That doesn't mean, nobody on the North Marshall Water Board was ever arrested, but they were removed. And so that's what I need. I can't sit up here and say that I'm never going to bring up the refuse board issue because you still have the same people in place that made those decisions.
You have a new issue, you can address it, and we'll follow up.
Or the same issue. It's never been resolved. They're still in place.
And I'll say publicly, and I look at all these people, every one of them in this room, and tell you that I think that board and their new superintendent out there are doing an excellent job now. That's my
We
opinion.
appreciate it.
All right.
That's all I have.
Thank you.
Thank you.
Eric Long?
Judge, if I could occupy the seat.
Yes, sir.
Papers out might be a little easier.
All right.
Good morning. I'm here on behalf of Sue Hohen, Edie Hutton, and Marlene Grims. They're all owners of property in Grandview subdivision. Recently, the owners of Grandview subdivision decided to construct a fence along the border of their property that adjoins property that's owned by Jeff O'Brien. They constructed their fence on the understanding that the county road ended and I've got a copy of the plat here, but the county road ended, which would be Hickory Hill Lane, at the corner of where Grandview subdivision begins, which is also the corner of the property of Jeff O'Brien. My understanding is there's been a complaint since then that maybe the county road does not end there, and that portion of the fence would need to be removed. Now, all the owners of Grandview subdivision have always considered this a private drive, and in fact, that's what they want, this to be a private drive. The only place it leads to is to Grandview subdivision, and they've even considered putting a gate up there wherever the county road ends. And so, in essence, the question that we're here, that I would like to find out, get some more information on is, where exactly does Hickory Hill Lane end, based on the fiscal court and the county records? How wide is that? And so they have no intent to be in a dispute with the county and to obstruct the right-of-way, but we do need to find out exactly where that point is so they can put their fence where their fence is allowed to go. And I can pass this around if anybody wants to.
Terry, I think you've
Eric,
looked
we
at
drove
that.
out there, Russell and I did, and looked at that with Mr. O'Brien. And I spoke with the county attorney about it, and I spoke with the judge's office, and they had the computer pulled up, and we searched the records and found in 1997 that the county had taken that road into the system, and it's 1,662 feet long. And Russell and I measured it with his device, and that's exactly how long it is. From Reed Road to the end of the blacktop is 1,662 feet, and the right-of-way was, do you remember, Russell, 40 feet? And we measured that, and from what we did, if we're not wrong, I'll say emphasize if we didn't make a mistake, the fence is well on the county right-of-way.
The 1662, where does that begin?
At the intersection of Reed Road, where the roads come together, is what I understood. That's where we started the measurement. That's according to the ordinance, or the minutes of the meeting, I'm sorry, not ordinance.
The intersection of Reed Road and Hickory Hill Lane?
Yes,
And when did you say that was 1997?
1997, according to the county's records.
And would that be the 40-foot width, would that be from the center line of the current blacktop
Yes.
all the way down through until
No, we started right there at the edge of the road. not the center line of Reed Road.
No, I think he's saying the right of way,
You said it was 40 foot wide, and I'm just saying the
Okay.
center point would be where the
the
blacktop.
center of the blacktop,
Under the blacktop.
20 feet either way,
side.
right.
Right.
What we normally do.
Okay. Well, and essentially, like I said, that's the information that we wanted to get today. Can I get a copy of those, the record, 1997 records? Somebody send those to me, just so I have them.
Sure.
You can probably get, well, you can probably get them on the way down, it's Justin down. You can send them to him, whatever, Judge.
Okay.
Yeah, we can get them to you.
Okay. Well, what we'll do, and I'll talk with my clients and just go out there and take a look. Now that we've got this information, and certainly we'll address it accordingly if it, you know, if we think that there may be a mistake on some of the measurements, then we'll come back. If not, then it'll be addressed.
Yeah, we can remeasure, and if you want to be present, whatever.
Sure. Okay. That's all I have.
Does the fence need to be tucked up until something has been made clear?
Well, I mean, we intend to address it accordingly. I don't necessarily know if it's going to be today, but within the next 10 days, and I'm certain we'll have a chance to look at it and do what we need to do. If it looks like it's on the right of way, which you're indicating it is, then we'll certainly move it back.
What if he needs access to it before the 10 days?
Well, I suppose in turn, I mean, that's assuming that he does have the right to have the access. You know, I don't, there's obviously a disputed matter here between Jeff O'Brien and the folks at Grandview subdivision. It's got to be sorted out, which,
According to his deed and our records, the county right-of-way joins Mr. O'Brien for several feet from his corner post on the road, so
do you know how many feet that it adjoins him?
what'd you
Mr.
guess,
Carter is
Russell?
here
50?
representing Jeff, I believe.
Judge, thanks for recognizing me. We came here really for the purpose of observing. We knew that the letter had been sent. Appreciate the opportunity to speak to the board. The concern that Mr. O'Brien has at this point is that while this fence has been up, he has 28 track out there that lies adjacent to Eric's clients, and he's completely denied access to that property because of this fence. And I think this fence extends about 70 feet. So there's 70 some odd feet of fence in an area that prohibits him access to the public road. And as I hear this discussed, he's been denied access now for several weeks, and I'm not hearing that that's going to change anytime soon, Judge. And I simply, on Mr. O'Brien's behalf, like to address the court and know when that fence is going to be taken down. He's been a very patient man. I could have told him to take a piece of equipment out there and run the fence over and be done with it, but he's not done that. He's trying to do this the right way, and we would appreciate the court's assistance in getting this fence removed ASAP.
How much access does he need from the corner post there to, I mean, I think that in terms of where their corner post ends, so many feet down, I don't think we can, I think that an agreement can be made that they'll certainly give him access right there until we get this resolved. For so many feet, I don't know how many feet you're talking about.
Well,
20
I'd say
feet?
he wants 30, 40 at this point. Okay.
Well, I think the one thing that we're missing here is you guys are talking back and forth, and the way I see it is the county owns that right of way where the fence is.
That's exactly
I
right.
think we need to be taking the fence down.
That's why Mr. O'Brien has not done it.
What do we need to do, Jeff? We've taken every step. Is there anything else we need to do? We've measured, we've looked
No,
at the
I mean,
deeds.
if you determine it's on the right of way, you can take it down.
It's, according to the measurements, it's definitely on the right of way. Now, the only thing I can't say for certain today is from Mr. O'Brien's corner post of his property, how many feet, I could only guess 50 to 75 feet down the property line before it runs back into their property, because it comes in as a Y. So he probably has 50 to 75 feet at least where the county joins him.
Well, Judge, we simply asked that the fence be removed from the county right of way, because it inhibits his access to the property.
We'll make the motion if it be removed. If these folks want to remove it, or if not, then I think the county should go and take the portion down it's setting on the county right of way.
One thing I would mention, you had mentioned the 40-foot wide, and I do know that the road goes in and it makes it curve. And so,
That's where it runs off of, that's where they come back into contact. He doesn't own. There's a V, it comes into a V. but now he owns down to a point. When you measure 20 feet from the center of the road, and eventually you're gonna run off of his ground. But for a few feet, it's on him. But eventually it's gonna run off. See what I'm saying?
Well, and I guess that's the other issue is the road, again, it goes straight and then kind of curves to the right. Where it curves to the right, that 20 feet from the center line is obviously getting farther and
Right,
farther
right. And it
from his
won't-
property line. And so
Right.
the entire fence, I don't know if that's been measured as far as the entire fence, because the fence goes in a straight line.
No, the entire fence is several feet way on down there. We know that's not, he knows that's not his. But where his driveway that he's put in is obviously on, the fence is obviously on the county right of way.
And I guess so when we're talking about removing the fence, and that's my question, is you're talking about the entire fence?
No, I'm talking about
No, and
50 feet maybe.
Well, I
40
I
feet.
The
understood,
debate is how much of the fence is on the county right.
Right.
That should be removed.
We can
Yeah.
measure that, we can remeasure that. I can't tell the court today how many feet that is from his corner post down the property line before it runs back into those people's property. But Mr. O'Brien would own, I'm gonna guess 50 to 75 feet. The county right of way joins his land.
I will make a point, Mr. O'Brien doesn't care what kind of fence they put on their own property, but when they fence county property, they're accessing his, that's a problem.
Well, I just make the motion that we remove it. I think they should, or if they, are they here?
well,
If-
Do you go and
Well,
break that down, or do you want
how do we,
do you want us to come and measure and you be present, let's show you?
that's what I was gonna ask. I wanted to make sure that you all were
Russell and
there
I'll
so
come
that,
down and measure and put a stake, if everyone's in agreement, we can remove the fence to that point. That satisfies everyone. Good, that's what we'll do.
well, if I'm understanding everybody, Jeff is just wanting egress and ingress to his property. And if I understand Mr. Long, these folks don't want to be on county right of way and they're willing to get the fence off of the right of way. So hopefully we can, by agreement, without having to go to a bunch of court action, try to resolve this thing. So Mr. O'Brien will have access to his property and they will have security of their property as long as it's not on the right of way. Terry, when could y'all meet with them?
If you leave contact information, I can contact you. Russell and I will come out and make the measurements when you can be there, if that's okay. If you leave
And
your
I'd like to
number
do
or
that-
something where to reach you before you leave today.
If we could do that in a very timely manner, because as Mr. Carter pointed out.
We could go, I can go today. I mean, that's after the meeting.
Okay,
You would even like to be there too?
yeah, Mr. O'Brien will be there, so, okay.
Okay, well, just leave, I treat you to say, just leave contact information and we'll accommodate you.
All right.
Okay.
Thank you.
Thank you.
Let's move, anybody else here to address the court? Let's move into correspondence from,
But, Judge?
Oh, I'm sorry.
Mr. Carter, they're indicating Friday. Is that okay with your client?
Apparently so.
Okay.
Thank you.
from Reverend Tim Polly on behalf of First Christian Church in Benton and Marsh County Emergency Responders Alliance. We'd like to thank you for your support of this project. This is the Jeff Billingsley event. Over the course of the event, Mr. Billingsley had the opportunity to visit with several emergency service agencies as well as several citizens of Marshall County. Over the three-day visit, Mr. Billingsley was able to witness to and lift up over 200 of our Marshall County emergency service professionals and their spouses. Whether you supplied items or services for the project, and the Billingsleys or kept this event in your prayers, we are truly grateful for your contribution and well wishes for a successful event. Mr. Billingsley's book, My Second Chance, will be available for purchase in about 1 month, and we are confident that it will touch all who read it. Thank you for your support, Reverend Tim Polly. From First Lady Jane Bashir, dear Judge Miller, and each county received a copy of this letter. On January 20th, 2014, the Commonwealth will celebrate the 100th anniversary of the Governor's Mansion in Frankfort. As you know, this historical landmark has been home to 25 governors and their families and has served as an impressive setting for welcoming dignitaries from across the globe as well as the citizens of the Commonwealth. In honor of this occasion, Steve and I, along with former governors and their families, will host the Mansion Centennial Celebration, a week-long series of events that will highlight the role of the governor's mansion that it has played in Kentucky's past and its potential impact on future generations. In addition to the celebratory events during the week of January 20th, 2014, we're asking your county's assistance in a special Mansion Centennial Legacy project that will benefit Mansion guests for years to come. The current chairs that are used for large seated events at the Mansion are in ill repair, unsafe for guests, and in desperate need of replacement. With tightening budgets and difficult financial times, we have delayed replacing them until it is absolutely imperative to do so. As a long-lasting gift to the Commonwealth, the Kentucky Executive Mansions Foundation, a 501c3 organization, has contracted with Berea College to produce 120 new, durable, functional, and beautiful chairs for use at the mansion. These chairs will be handcrafted of locally sourced, sustainable maple wood and are being designed, built, and upholstered by Berea students. This is a truly once-in-a-lifetime, entirely Kentucky project. The wonderful people of Marshall County can be a part of this legacy by sponsoring a chair in the county's name. We are asking that you, as a leader of the Marshall County, identify individuals or organizations within your county or fiscal court that would be interested in being part of Kentucky's history. Each county that facilitates a tax-deductible donation of $1,000 will have its name placed on a plaque on the back of a chair and be invited to attend the special event at the mansion on Tuesday, January 21st, 2014, for the unveiling of the new chairs. In order to assist us with appropriate acknowledgement of contributions, if the county or citizens, if you'd give us a name and address of each contributor, they'll be able or eligible to receive accommodation from the Mansion Committee. Steve and I hope that all 120 counties will be representative at the Mansion for years to come through this important project. This is signed Jane Bashir. They've sent these to each of the counties if they wanted to participate in this. Must be pretty nice chairs for $1,000 a chair.
I was thinking.
I mean, I'm not just saying.
Any furniture comes from Berea.
It'll be done right.
It'll be very-
Yeah. But y'all want to think about this for a while, and we'll bring it up again at another time? Okay. From Deborah Conway, the supervisor of the local assistance section of Energy and Environment Cabinet. On August 27, 2013, Lisa Evans met with Jeremy Perrin and Troy English to discuss the implementation of the Marshall County Solid Waste Management Plan approved by the division on December 20th, 2012. I'm pleased to inform you that Marshall County is in compliance with its 2013 through 2017 Solid Waste Management Plan. We believe your county has made progress and needs to continue to implement the solid waste management system as outlined in the approved plan. The participation rate for Marshall County is 100%. This is above the statewide average of 86.9%. All haulers are required to register and report to the county the total number of households served and the tonnage collected by February 1st of each year. This is a requirement of KRS 22443-31, or 315, Section 2 and 3. The county is commended on doing a good job in getting the hauler registrations for 2012. Record keeping in regard to the implementation of the 5-year plan is becoming more important. Documentation of milestones in the plan should be maintained. For example, an education file containing copies of newspaper articles, flyers, a listing of school presentations, and other education activities should be available to document the educational activities. Please contact Lisa Evans or myself if you have any questions. We look forward to continue developing the solid waste system in your county. Deborah Conway. 100%, I don't guess you can get any better than that. We appreciate the good work that they're doing. Let's move into old business. You've all received the minutes of the September 3rd meeting of the fiscal court. Any corrections or additions to the minutes of the meeting?
And motion approved.
Second.
I have a motion and second to approve the minutes. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. Crooked Oak Loop, I had someone ask me the other night what we had done, and it was my understanding that they needed some additions, Jeff, to the,
Yeah, that was outlined in the minutes in the last meeting.
has anybody contacted you on,
No, sir.
making what changes we need to make, or Terry, have you heard from anybody?
No.
Okay. Fellow just asked me, I saw him the other night, and I told him that, they needed to do, it was something with the petition, is that correct? Yeah. Several things, okay.
Well, there were several things, but if you remember, we addressed those at the last meeting. We were aiming for have the road viewers to look at it to see if there's any need to proceed further. We won't need that information if the road doesn't meet the specs anyway. If we know we're gonna turn it down, there's no need in obtaining all that, right?
Well, yeah, I think one of the things that was determined was it's real narrow in certain points. However, there is a 40-foot right-of-way, is that right, Russell?
Yes.
40-foot right-of-way, but you and I drove out there on the road, and it seemed to be,
Around 14 and a half, 15 foot's about the widest it is.
you know, it really wouldn't, you know, we've got some roads, I guess, from years back,
I
Terry,
think the
that,
only question now is if it meets the existing road requirements of 15 years, which I think it probably does.
yeah,
If we had that information available, we'd know that. That's the only question. But after that, then we would be responsible for half if we were to take it in.
Yeah.
But that's the only question that needs to be answered at this point, if it meets that. I'll try to get with Mr. Sires and get that information together and see if we
okay,
can.
yeah.
Sure.
I think y'all have already looked at it, is that right,
Yes.
Russell?
Yes.
And the narrowness was the big concern, I believe.
It's got a couple of culverts that needs to be replaced.
Okay. All right, Will,
And also a cul-de-sac, if that right there is gonna be determined a dead-end road.
see, there's part there, Terry, that on the plat, it goes kind of on around, but it was never developed.
Yeah.
So, you know, we say in our ordinance, if you're gonna dead end it, you gotta have a cul-de-sac. Is that
I'm
right?
not sure it
Right.
has, but doesn't it say 2 houses per quarter mile? Well, it has more than that, doesn't it?
I think it does.
Did you find that when you looked that up?
Well, there's no proof that they've been in existence for 15 years.
Yeah. Right, yeah, but
Yeah,
there,
she
Well, they
outlined
first
each of those.
approached
I drove
us.
the road. I know Jim Sires and some of those have been there. That's the only question. I'll find that out by the next meeting and then we'll know.
Well, they first approached us, when it was still gravel, Terry, before you were on the court.
Right.
So I'm gonna say some of those houses, maybe most, I don't know, have been there the required 15 years, but I guess we need to find out for sure.
I know Jim was there when back at least that long.
Yeah,
So I can find that part. I can find that out.
Okay.
Then we'll know if we need to proceed on or not.
okay, all right.
If they turn it into a cul-de-sac, then whoever's property line that goes past the 40 feet would have to quit claim that.
Right.
Yeah, in order
Yeah,
to do
get
the
it.
cul-de-sac, yes, I understand. Wave Avenue, we talked about that at the last meeting. Russell, did you take a look at that? That's where the storage building is there?
Did, I believe.
Oh, Josh, where's Josh?
Yeah,
We didn't-
I just drove out and looked at it, Judge. The gravel goes back past the apartments and back to the storage unit, and then On the other side, it's just earth base, best I could tell. We haven't, did we get a petition on that to do a road report? Or-
We got it. We
I
received a
don't know, I just
petition.
called out and looked at it, I didn't officially do a report or anything.
Okay, we did, well, we did get a petition, did we not?
We got a petition, but they were holding up on it to see if it met any of the criteria prior
They
to.
filled it out on the old form, and we don't know if they're petitioning it as a new road or an existing road.
I talked to Paul Cloud, and he said that, it was an existing road, and,
It's been there
the
18,
petition
20 years.
form, the front page of it was on the new form, and the second page may or may not been from the old form, I don't know.
So we need to have our road viewing committee go out and see if it meets the standards and criteria for existing.
Yeah. That's one I think I've spoken to Jeff about. It doesn't, there's no description in the ordinance much of anything. There was no homes on there. There was those storage buildings, and they've been there. And I talked to Mr. Sutherland and said they'd been there 18 years. And the public's used that section for 18 years to go in and out of there. So I don't know if that would meet the existing or not.
I don't think it would, because from what I was digging around, from what Anita had sent me, it said it had to have 2 businesses or homes within that quarter-mile section,
But it's not a quarter mile long.
yeah,
Right.
so.
And you,
So what do we do when
So is
someone
it just-
comes in
it's just-
petitions a road at 600 feet? What are we gonna do with that?
it's just one business, is that right? No homes, just
No
the
homes.
one business.
See, and I think in Calvert, seems like we have some roads over there that have only businesses on them that are 400 or 500 feet long. And when we have a situation like this where this comes up, what do we do with those roads that the public are using that has a storage facility or whatever on it, and it's like 400 or 500 feet long? What do we do?
Well, I mean, when we drafted that, the court didn't intend to take, I mean, they considered those driveways and not necessarily county roads.
Right.
And, I mean, if the court wants to establish a policy for those short ones, that could certainly be. That was just something that the fiscal court didn't address
They-
specifically.
Right, they were just asking to be considered an existing road, and it now has several families living there, and now I think there's maybe 8 or 10 families living in that loop. In those
On Crooked Oak?
apartments. And no, in Wade,
Oh, wait,
yeah.
Well, I mean, it could be taken in as a new road if they brought it up to the specs.
Right.
Are they
But
willing to
then
do
they'd have
that?
to pay- They were wanting the county to absorb half the cost, I guess. They wanted it to be an existing road, or at least that
Yeah, I
portion
mean, the
of it.
court just back then, when we did that, limited what they would take in as an existing road. Anything else would be
I didn't know what to tell them, and I didn't know if there'd been an exception because of the distance being that short, and it being a business on it, not homes, and we had not addressed anything like that
there's
before.
not any,
since
not
I'd been-
anything,
no,
no,
I
there's
don't
not an
think we've ever
exception.
had something like that there.
It says 2 residences or businesses. So was
It could be a business.
Right. But that's per quarter mile, isn't it?
it just says the road must contain 2 residences or businesses, and then each additional quarter of a mile shall contain at least 1 residence or business.
See, and this is not a quarter of a mile. It's not even near a quarter of a mile. I don't know how many feet, but
So would that meet the standard?
It's not a minimum.
Well, that wouldn't.
No, apparently there's not a minimum. Then it might qualify, if it qualifies for other reasons.
So,
we just need to figure it out, I guess.
Well, let's look into it. I mean, the business has been there, what'd you say, Terry, 18 years?
Johnny said 18 years that
18
he's had
years.
those storage buildings there.
And now there's some houses.
who needs to make that determination? Jeff?
Well, it's not even 15
Maybe all of
100
us.
feet long.
No, not 15 years.
The houses, I don't know how long they've been there.
Jeff, who makes that
Last year, I
decision? Do
think,
you
was the
need to
first one. They're all new.
review it or,
Well, we can look at it and make a recommendation
Okay.
to you all.
All right, if you do that, have us a recommendation for the first meeting in October. Because we need to, well, on both of these, we need to tell them something. Next is our second reading of ordinance 2013-07. This is an ordinance relating to the adoption of the 2013 Marshall County tax rates. Whereas the Marshall County Fiscal Court adopted the 2013-2014 fiscal budget on the 25th day of June 2013, and whereas the Kentucky State Revenue Cabinet has certified the county property assessment. Real estate, $1,724,580,828. Tangible personal property, $183,857,227. Public service companies, $100,297,708. Motor vehicles, $237,942,227. Watercraft, $24,263,101. Aircraft, $123,267. Non-commercial watercraft, $8,797,848. Inventory in transit, $115,559,864. Now, therefore, it is ordained by the Marshall County Fiscal Court, Section 1, in accordance with KRS 68-245 through 68-249, there is levied for the year 2013 the general ad valorem tax per 100 assessed valuation on all taxable property within the jurisdiction for the general fund and such additional tax rates for each special district or other fund as indicated. General fund, 9.9, real estate, 10.83 tangible. Health district, 7.5, real and tangible. Hospital district, 3.8 real, 4.3 tangible. Library district, 9.6 real, 9.6 tangible. Refuse district, 9.4 real, 9 cents tangible. Extension, 1.8 real, 1.8 tangible. Soil conservation, 1/2 cent. Aurora Fire District, 9.5 tangible and real. Gilbertsville Fire District, 7.5 tangible and real. East Marshall, 9.4 real and tangible. Possum Trot Sharp, 6.8 real and tangible. Bryansburg, Graftonville, Palma, 10 cents real, 10 cents tangible. West Marshall, 7.5 real, 7.5 tangible. Fair Dealing Olive, 8.25 real, 8.25 tangible. Hardin South Marshall, 10 cents real, 10 cents tangible. Section 2, in accordance with KRS 132-487, there is levied for the year 2014 the tax rate of 11.2 cents per $100 value of the taxable value of motor vehicles or watercrafts registered in Marshall County. Section 3, in accordance with KRS 136-575, there is levied for the year 2013 the tax rate of 25 thousandths of 1% on bank deposits held by all financial institutions within the County of Marshall. Section 4, this ordinance shall be published in the Tribune Courier newspaper by title and summary within 30 days following the adoption. This ordinance becomes effective upon passage and publication. The first reading was held the 3rd day of September 2013. What's your pleasure on the second reading?
Make a motion, Judge.
We have a motion. Is there a second? Second. Motion and second. All in favor of the motion, say aye. Aye. Any opposed, no. Motion carries. This is 17.
Yes, sir.
Next is a second reading of ordinance 21308. This is in regard to the Marshall County Tourism Commission. Now therefore be it resolved and ordered by the Fiscal Court of Marshall County, Kentucky as follows. The ordinance of November 17, 1970, and all further amendments made prior to the instant ordinance by the Fiscal Court of Marshall County are hereby amended and replaced by the instant ordinance. 1, the Fiscal Court authorizes and establishes the Marshall County Tourist Commission pursuant to KRS 91A 350, KRS 91A through 360, and KRS 91A 390. 2, members, duties, vacancies, expiration of terms. Members of the Marshall County Tourist Commission will be chosen in the following manner. 3 members will be appointed by the county judge executive, chosen from a list of 6 names submitted by the local Hotel Motel Association. If no association exists, the 6 names will be submitted based on their representation of the local hotel industry. B, 1 member will be appointed by the county judge executive, chosen from a list of 3 names submitted by the local restaurant association. If no such association exists, the 3 names will be chosen based on their representation of the local restaurant industry. C, 1 member will be appointed by the county judge executive, chosen from a list of 3 names chosen by the local chamber of commerce. If no such chamber exists, the 3 names will be chosen based on their representation of local businesses. D, 2 members will be chosen and appointed by the judge executive. E, all appointments will be made by the county judge executive within 30 days of receipt of the names. Each member of the Marshall County Tourist Commission will serve for a term of 3 years. Vacancies in the commission will be filled in accordance with Section 2AI of this ordinance and KRS 91A 360. Appointments at end of terms. Upon the expiration of the term of any member of the Marshall County Tourist Commission, the former member will hold over and serve in their capacity as acting members until such time as an appointment is made to the judge executive. Members of the County Tourism Commission are not removable at will. They may only be removed from office by the county judge executive or officers of the fiscal court for inefficiency, neglect of duty, malfeasance, or conflict of interest. The procedures for removing members are outlined in KRS 65007. Each year, the commission will request funds for operation from the fiscal court. These funds will be raised by levying a transient room tax. The fiscal court hereby levies a transient room tax of 3% on the gross rental income from persons, companies, and corporations operating as hotels, motels, bed and breakfast establishments, motor courts, and vacation home rental operators in Marshall County, Kentucky, to be collected by such persons, companies, and corporations on behalf of the Treasury. Persons and companies and corporations operating as hotels, motels, bed and breakfast establishments, motor courts, and vacation home rental operators in Marshall County, Kentucky must, on or before the 20th day of the month following close, file a return with the treasurer of Marshall County of other designated agents of Marshall County, setting forth the aggregate amount of the gross rental charges during the preceding calendar month for every occupancy of a suite, room, or rooms, together with such other pertinent information as the treasurer or designated agent may require. Such information shall be confidential in nature and not be open to inspection by the public, but shall be for the use and benefit of the designated agents of the Marshall County Fiscal Court and Treasurer only. A fee of $250 shall be imposed on each failure to file a return on or before the 20th day of each month following close. This fee is in addition to any other penalties, interest imposed for a failure to tender the collected tax. Interest at the rate of 0.5% per month will be imposed on each month the transient room tax is not paid. Additionally, a delinquency penalty at a rate of 1.5% per month for each month the transient room tax is not paid. In addition to fees, penalties, and interest, any person or business failing to file the transient room tax will be subject to criminal prosecution. Failure to file will constitute a violation under the Kentucky Penal Code. The records of the commission shall be audited annually by an independent auditor who will make a report to the commission, to the associations from which the members are chosen, to the county judge executive, to the state auditor of public accounts, and to the fiscal court. A copy of this audit shall be made available by the commission to members of the public upon request at no charge. Each section and each provision of each section of this ordinance are severable, and if any provision, section, paragraph, sentence, or part thereof of the application thereof to any person, license, class, or group be held unconstitutional or invalid for any reason, such holding shall not affect or impair the remainder of this ordinance. It being the legislative intent to ordain and enact each provision, section, paragraph, sentence, and part thereof separately and independently of every other. The provision of this ordinance will take effect on passage. The first reading was passed on September the 3rd, 2013. What is your pleasure?
Make a motion.
approved.
Second.
Let's go ahead, you didn't ask me to read it again. We have a motion and a second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Who made that motion?
Bob.
Bob? Misty, second. All right, Sled Creek Road, I know y'all were looking at that. Did we
We-
get that figured out?
We've got a measurement of 1.99. If you all could measure that and see how far that goes. Mel is in the process of looking through the records to see if she finds any request for them not to pave that particular end section. And then I'm requesting from the state their official transfer measurement, just to make sure that all those records match up. So hopefully by the next meeting, we'll have all that ready. I'd hate to make a motion now. The only way I think we could go ahead and make a motion to go on down is if the 1.99 includes that area that wasn't paved at the end, because we've already got approval in the rural secondary program to pave the 1.99. So if it's included, I would make a motion, I guess, that we go ahead and pave through the end of Sled Creek, where we already own that road. It's just, it's not paved at the end. About how much farther down would you say?
Probably 150
100,
foot,
yeah.
200, something like that.
What was your motion again?
If it meets the requirements, if that is road that we already own and it should have probably been paved, with the exception of somebody just requesting that it not be, I'd make a motion that we go ahead and just pave that additional 150 foot, if we already own that roadway. If we don't, then obviously we'll come back at the next meeting and take a look and see what that request was, make sure we have permission from the property owners, that sort of thing. Unless you all think we need to go ahead and get that in writing now that they're requesting it prior to.
We never could figure out why it wasn't done.
We can't find it. She's digging through records to try to figure out if that was requested by an individual. That's what the property owners seem to think, but we have to find that, I would think, before we could.
Judge, is it our road? We know it's our road.
Yeah, it appears to be our road. For some reason, there was about 150 foot that did not get paved, going back to a driveway back there.
The property owners say it just drops off short of the end of the road, where it still leads to several people's driveways. It's not their driveway, it leads to their driveways. And the story we hear is that the prior owners didn't want that to be paved because they didn't want that access. They wanted that to be theirs and theirs alone. So, as long as we own it and we already have the funding for the rural secondary program, I don't see why we couldn't go ahead and do it, unless you all see an issue with, as long as it's already in the
I never
system.
knew why it got left off. In fact, it was brought up. I wasn't aware of it.
Well, there's the if we own it. I'd
Yeah.
second that if we own it.
Yeah.
But
Well, I
we need
think-
to make sure it's our road.
Misty, you stipulate that in your motion
If
to
it,
make
yes, as
sure-
long as the
as
measurement
long
is,
as
if it's
it's
included in
our
that one
measurement,
point nine
or-
nine, yes,
Correct?
mileage
That,
measurement.
We'd go ahead and put that down for payment. Is there a second to the motion?
Yes, second.
Motion is second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. Animal ordinance. We have in our presence today the Honorable City Attorney of Calvert City, and the City Attorney of the City of Benton, and the City Attorney of the City of Hardin. We've got all the players here. Where are we on our ordinance?
Well, we have a draft that has been circulated, a basic draft, and I think that both cities have reviewed that. Do you have any suggestions or changes that you'd like?
Well, I think the city of Benton was the only one that really had some concerns about the provisions of the ordinance as it existed, and I think Greg and I have talked about it, and Jason and I have talked about it, and Jeff and I have talked about it. The provisions that we felt like we needed was for more concentrated areas. We wanted the city of Benton to have a leash law, and I think I've drafted what I proposed would be appropriate for that section. We kind of circulated that, and I don't know that anybody else thought that was a good idea or didn't think it was a good idea. But we kind of left it that we felt like the city of Benton needed leash law. We also wanted it to be applicable in the parks. We felt like it ought to be applicable in Mac Miller Park, but we got kids that walk out there. We didn't think it was appropriate for you to have a dog running loose in an area like that if we were gonna have people out there. So I think when we got into the discussion, it was, we felt needed some kind of restraint on dogs that were being walked and out. And that, as I said, that's where we got to that point. I think it kind of, that's where it sits. We feel like we need that if we're gonna adopt your ordinance and make it an encompassing ordinance for the community, all the communities in the county. And we felt like we needed that one provision that would be applicable in the cities. And I think the discussion we had, we would put it in and then either give them the opportunity to opt out if they didn't want to have a leash law in their community. That'd give Hardin and Calvert an option. If they didn't want to make that applicable, they didn't have to. But we felt like we needed it for the city of Benton, and basically the city council thinks that's imperative.
We've already got one in Hardin. We've already got a leash law.
I thought there was a leash law in Hardin. Greg, do y'all have a leash law in Calvert?
Calvert doesn't have a leash law. They've got several versions of dog ordinances and animal ordinances, but they've never actually had a leash law. I don't know if they wouldn't want to do that, but historically, they've not ever done that.
Right. So, in other words, Marty and Jason, if we adopt an ordinance, as long as we keep in the provision that the city of Benton, city of Hardin, and Calvert, if they so choose, enact a leash law. We talked about this on several occasions, and a leash law is just almost unenforceable out in the county. I mean, it just,
I don't think you need one in the county, but you do need one in more confined areas where there's a lot greater concentration of people.
particularly children, like you said, in the parks.
I guess my question for Corey is, what kind of regulations are y'all wanting to see, other than a leash law and the...
I'd like to see a basic agreeable fee structure so that when animal control goes out and they're answering calls, it's uniform. Obviously, if Calvert doesn't have a leash law, it won't even apply, but a uniform fee structure for the city of Hardin and Benton would be very helpful. And
Talking
then,
about for violations? of
yes,
leash
for
law?
violations. I'm assuming they're going to be the ones, we had talked about animal control being the ones that would actually be issuing the tickets or citations on those sorts of things and carrying those cases through court in the event that that was required. But some sort of a uniform fee structure as well as an agreeable amount, if any, that the cities would be requesting. I know at the city of Benton did have a fee structure and schedule to where if animal control took in an animal from the city of Benton, they actually recoup some of the fees, and it was discussed that the city of Benton, if animal control through the county handled those cases, would possibly be agreeable to letting animal control recoup those fees. So some sort of an agreement as to where those funds would go, and if the cities had some sort of a particular request for how those funds were used. I think if we knew that up front, it might prevent any sort of an issue later on, because let's say 75% of the fees come from the city of Benton, you all might have a vested interest in how those funds are used, and it'd be better to know that up front, I think, than 3 or 5 years down the road. So those sorts of things I think would be
Well,
important.
see, I think what the city said was, if we get an ordinance that you all feel comfortable with, that we can use in the city of Benton, we're going to just do away with the ordinance.
So you'll be
that we
okay with
have.
that? Okay.
Just repeal it entirely, fall directly under the county's ordinance, and then let the animal control officers take care of the city as well.
Okay.
That way, if there are fines and assessments, and the city has no interest in those, because it's a county ordinance.
Okay.
And I think that would probably be easier for us to administer. That way you don't have any duplicated service, we wouldn't have the ordinance, I mean, our code enforcement board wouldn't be having to deal with the animal issues anymore.
Okay.
And we could just leave it for the county to take care of in that, under your ordinance. Now, I'm not sure how you're all gonna enforce it, but you're gonna have 2 animal control officers, I think, at least, aren't you?
Mm-hmm.
And they'll be doing have the responsibility in the city of Benton. And if they assess a fine or a penalty, I'm not sure how you all are gonna enforce that. Do you all have a code enforcement that you're gonna proceed through, or are you gonna put it in district court? What do you?
Well, I mean, I mean, not often, but we have cases come through district court, and, you know, we deal with them.
How do you all deal with the money that's collected under, if it goes to district court? We always had trouble with that for city violations, and
If it's a-
the money the state wanted, and that's why I say, well, I'm not sure how you all intend to enforce that.
Well, the court costs are split up according to ordinance and statute. The fines, I'm assuming, have all gone to the general fund, the state.
The state's general fund.
Right.
Yeah.
So, to me,
I
I
don't
think
I don't know of any time that have we received any money for any animal violation?
I don't think so.
I don't think so.
That's why I say I think
I don't remember
you all
ever
need to take a look at a code enforcement, county code enforcement board or something of that nature, so that we can keep the fines and those kind of things on a local basis. Because if we do what is customarily done, those fines will be collected in district court, that money will go to the state. We'll get some portion back based on an agreement that was in place, and I think 20 years ago when they enacted the district court system, and you get a minute part of that back every year, I think at the end of the year. But to
Yeah,
me, I think if we were gonna really seriously consider what you're talking about, Misty, we're gonna have to use a different kind of method of
Okay.
enforcement.
I think that's a good idea, as well as recouping
If it goes to
some.
district court, I don't think we have any control over where the money goes.
I think it needs to be handled a little differently anyway, just not to congest that any at all. You know, as well as I do, the city of Benton said that they hadn't even been issuing any citations off of the ordinance, but there's a lot of associated fines and fees that could have been obviously cited. My only question is, there's quite a few provisions in your current ordinance on aggressive dogs. Are any of those going to be transferable? Did the city council indicate that they had any request?
I think your ordinance addresses that.
Okay.
The way Jeff has prepared it, I think we probably have overkill.
Yeah, there's a lot.
Because we cover everything from snakes to turtles, whatever. I mean, when we put it together, we got some, be honest with you, we got help from other larger cities, and they had dealt with problems that we never even thought about, so.
So you're okay with the verbiage as it
I
exists?
think what Jeff has provided would be adequate for
Okay.
the city. And if we find that it's not, there's no reason we can't amend it later.
Sure. Okay, thank you.
Judge Miller, I don't know if you've had any calls or not, but I've had people say something about pit bulls. They're wanting us to enact something to prohibit people from having them. And I don't know if anyone's heard
I'm
any of that
opposed
or
to
not.
that. I am so opposed to that, only because, I mean, it's, you know, we have had some issues of aggressiveness with pit bulls, but we have more dog bites from small lap dogs than we do from pit bulls. I mean, you hear about the ones where you have pit bulls attack somebody, but overall, and we had a veterinarian come into the shelter one time to kind of give us some education on this. As you know, Livingston County has some very aggressive
I
dog
think they just
legislation.
enacted an ordinance that prohibited
Yes.
pit
It did.
bulls.
Yes.
I think that's where these
Yes.
complaints came from.
It
Well,
is.
the city of Mayfield enacted a rather strict ordinance some time ago, did not prohibit you from having a pit bull or Rottweiler or what they call bully breeds. But if you did, you had to purchase insurance, if I recall. And I believe that ordinance passed the city of Mayfield, because if you recall, it's been years ago, we found a lot of pit bulls roaming the roads over in the south end of the county, where they brought them into our county and dropped them. And, rather than to,
That's really the problem in
Mm-hmm. There's so many.
Of these simple related large breed dogs
Yes.
that are just running loose, people claim ownership when
Mm-hmm.
it suits them
And not when it's not, right.
Well, the Livingston ordinance is the same about the insurance. They don't prohibit them, they require them to have insurance.
And the state of Virginia already has a statute on the books,
About
Yeah.
aggressive dogs,
the harboring of
vicious animals.
vicious animals.
Yes.
And many of these dogs, I mean, it took 3 men for that.
Mm-hmm.
yeah. Now,
Yep.
Jay,
Mm-hmm.
Why not have a blanket? Dog control over the county, and that take care of your cities and all. You know, I live out there in the county, and I had a guy tell me, Ridley moved out there, and he carried dogs with him.
Mm-hmm.
You're just responsible for your dogs, or a cow or a horse, you know? And they have a little bit of trouble with that, but they have 2 of them. Of course, I know there's no ordinance at all.
no, we have no leash law in the county, and the reason, Jay, that we don't, we have always felt that it's almost impossible to enforce a leash law in a rural area. Now, if an animal is doing damage to your property, if they are menacing in any way, Kentucky law covers that. I mean, if a dog comes at your property and he's growling and looks like he's gonna bite you, you have every right to destroy that animal if he's on your property. Now, we don't have that a lot, but I think that's what the law says, isn't it, Jeff? If they're doing damage to your property or whatever. But,
You get mauled out there on the road, it's no worse than getting mauled in town.
that's right, yeah, I understand what you're saying. I understand what you're saying. Any other questions? Yes, Greg?
Just clarification, Jeff, is the final draft, or the draft that everybody's looking at now, the one that was revised, that we made the revisions to when the attorneys all got together and looked at the terms, is that the one that we're talking about?
I don't think so, Greg. I think what I got from Jeff the last time, there are still those changes that we discussed that need to be made to the final draft before it's enacted.
Okay,
That, it's not in yours at this point.
okay, just wanted to clarify. In response to the question that was just being discussed, if I understand correctly, the ordinance that we're discussing defines running at large basically as any animal other than a hunting dog that's working, that is off the property of the owner, custodian, possessor, or harborer, and is not restrained. And then we go on to say, unless we've changed the provisions, any dog running at large may be picked up by animal control. Is that true, or
If it's off your property, yes.
if it's off your property? Okay. Just want to be sure I understood what we're talking about.
And that's consistent with the state law.
Right. But we don't have there's not a clean revised draft of the ordinance at this moment in time.
Not with the things that Marty talked about.
Let me ask you, could the attorneys get together, make those revisions that we've talked about, and have something ready for us, say by the second meeting in October?
Should be.
That would give you some lead time for all of you guys to get together and talk about it, so.
If it's, just to be clear though, if it's something that's covered by state statute, I don't think anybody's interested in being redundant in this ordinance. Am I right in thinking that?
That's the way I see it.
Okay.
State law, state law. Yeah.
Well,
Mark.
the only thing that I think we haven't addressed, and I think it goes back to the same question Ms. Drew had, that if you're going to do anything with this fine money, use it for salaries and those kind of things, and equipment and buying it, we don't have a mechanism for that. The only way we can deal with it under the ordinance as it presently exists, they'll be cited in the district court, and those fines and all that money will go to the state.
Yeah.
So if you all are talking, want to consider that, you're gonna have to do a local enforcement mechanism. I think you have a perfect right to do that, under the home rule statute, but you're gonna have to address that, and that's not something we've even approached yet, so.
And that would involve the creation of an enforcement board, like, you know, Benton has a nuisance enforcement board, and that'd be what we'd have to have for the county.
But it might be as simple as just replacing the criminal fine with a civil fine, just considering a civil fine enforceable as debt. We've done that in Calvert from time to time for specific type issues. And this might be the case where you could enforce in district court. Of course, I guess as the county attorney, you're going to be enforcing either way.
Right. Well, if y'all can get together and by the second meeting of October, give us something to look at least to consider, we'll take it up at that time. We have a business associate agreement. Emily, this is from Peel and Holland. These are our advisors on our insurance. Is the contract the same as it?
Yes, there are a few revisions that are required to be input in the contract, in the agreement, as regards to care reform, and this has to be adopted again. It's just slightly revised from the original contract, before September 23rd, due to health care reform. So that's the reason why we're readdressing it.
This is our relationship with Peel and Holland and our business agreement, associate agreement with them. Do I hear a motion that we continue our relationship?
Make a motion, Judge.
We have a motion. Is there a second? Second by Mr. Anderson. All in favor of the motion, say aye.
Aye.
Any opposed? No. Motion carries. All right, any other old business? Well, let's move into new business. We have an agreement between the Kentucky Department of Transportation and the Marshall County Fiscal Court and the performance of bituminous resurfacing on county roads. This is the agreement that we got through with our rural roads commissioner. I'm not gonna read it all, but it's for $311,000. And I had Russell pick out the roads. I'm not sure. Okay, New Harmony, Sled Creek, Hale Springs, Shemwell Cemetery Lane, Clemsford Estates. And then, that's not all of them, is it, Russell?
Well, that other is on the other money that we got.
Okay. This is a resolution adopting and approving the execution of a rural secondary program agreement between the Fiscal Court and the Commonwealth of Kentucky Transportation Cabinet, Department of Rural and Municipal Aid, and accepting all roads, streets referred therein as being part of the county road system. Be it resolved with the Fiscal Court does hereby certify that all the roads and streets referred to in said agreement are county roads as defined under KRS 178010, Section 1B, and the fiscal court does hereby ratify and adopt all statements, representations, warranties, covenants, and agreements contained in said agreement, and does hereby accept said agreement, and by such acceptance agrees to all of the terms and conditions therein stated. And the county judge executive of the county is hereby authorized and directed to sign said agreement as set forth on behalf of the fiscal court of Marshall County, and the county clerk of Marshall County is hereby authorized and directed to certify thereto. I would need a motion to approve this resolution.
Motion, Judge.
We have a motion. Is there a second?
Second.
Motion and second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. Squire Anderson and I have been working on a project. As a lot of you remember, Representative Coursey was successful in getting $700,000 to construct a new road over by the hospital to give entrance from the Oak Level Road all the way to the Simpsonia Road, thereby giving ambulances and emergency vehicles a lot quicker entrance to the hospital. We have solicited the help of the District Highway Office in helping us put bid proposals together because, quite frankly, Terry and I really didn't know what all to put in there. We knew basically what to put in, but they've got a copy of the plans and they're developing that bid packet for us. What I would like for the court to do is just authorize Terry and I, on behalf of the court, to work with the Department of Transportation in getting our bid packet ready. It may be on a month or two before we're ready to go to bid, probably next spring before we'll actually start building, depending on the weather, but we'll know by then how far our money's gonna go.
Make that motion, Judge.
We have a motion. Is there a second?
Second.
Motion and second. All in favor of the motion, say aye.
Can I say something?
Yes, sir.
My wife was at the hospital here last week, and a couple of gentlemen, and elderly ladies, and they had problems walking from the doorway to their parking area. I was just wondering if there could be any consideration, maybe having something to pick those people up, because those elderly people, they have problems walking from the door to their car.
Well, you know, down at Paducah, Mr. David, they at Lourdes anyway, they have a golf cart going around. Let me talk to our hospital board to see that they've got volunteer organizations there. And if we could get a golf cart to do that, to, you know, help people, because it can be a long walk. I'll look into that for you. Okay, a bid opening. We advertised for bids for an ambulance. Our ambulance director, I believe, is here. Marshall County Fiscal Court is accepting bids for a new Type 1 ambulance. Bidders must be QVM certified and comply with KKK-A-1822E. Sure y'all know what that means. Bids will be open September 17th, 9:30 at the Marshall County Courthouse. Bid packets may be obtained by calling the Marshall County Ambulance Service, 270-527-1243. The fiscal court reserves the right to reject any and all bids. I think we've got 2 bids. The first bid is from Osage Ambulance out of Lynn, Missouri. We've done business with them before, right?
Yes, we have.
Osage.
I believe those 2 bids are probably from 2 different dealers. So
Yeah.
I'm not sure what the
I'm-
address says on there.
I don't know, this other one, we'll see. But this first one, our total price complete as specified. This is from Southern Specialty Vehicles, West Jefferson, North Carolina. And their bid, total price complete as specified, $124,285. $124,285. Let's see, we're pretty tight.
Yep.
This next bid is from Emergency Services Supplies of St. Louis, Missouri. Their bid price for a 2014 Ford F-450 with Osage Warrior conversion for per year specifications, no exceptions, $128,375. $128,375. Brian, why don't you look at these before we take a vote? Run that them off if you want to, make sure they meet all of your specifications. I mean, the apparent low bidder is about 4,000, but let's make sure we're comparing apples to apples. We have two members of the North Marshall Water Board whose term expired, and I apologize, they expired 6/30/2013. I guess we need to take these one at a time. I would recommend the reappointment of Jerry Miller, 331 Castle Drive, term to expire 6/30/17.
Motion to reappoint.
Have a motion, is there a second?
Second.
Motion and a second, all in favor say aye.
Aye.
Any opposed, no. Motion carries. Next, Billy Driscoll, 615 Coldwater Lane, Benton, Kentucky. Term to expire 6/30/17. Do I hear a motion?
I recuse.
Make a motion, Judge.
Have a motion.
Second.
Second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. I just let that slip by. I don't know, I didn't notice that that expired. Okay. Treasurer's report. Emily?
As of August 31st, 2013, the general fund had a book balance of $171,781.46. Road fund, $1,097,558.78. The jail fund, $114,879.78. The grant fund, $6,526.87. 911 fund, $171,807.95. The occupational tax administrator fund, $2,144,035.55. And the veterans van fund, $1,652.67, for a grand total of all funds of $3,708,243.06. You will notice on the statements that are attached, I'm gonna put those in the order book, so yours doesn't have them. There are notes on the general fund, removing that amount that we addressed last court meeting, where the U.S. Department of Fish and Wildlife made that error, depositing that $139,895 into our account. And there also is a note in the 911 fund, where they had deposited road funds into the 911 fund, noting that those would be being transferred to the road fund.
Motion to approve the report, Judge.
I have a motion to approve subject to audit. Is there a second?
Second.
Motion and second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. As you know, because I think we've talked about it before, Emily has been working toward her training incentive by completing her recertification. This is something that we asked her to do. The incentive program rate for 3 years is $2,900, but since this is her 3rd year as treasurer, but she doesn't feel like this is fair since the first year she was able to train the certification was 2012. So based on that, the 2-year incentive would be $1,925.98. I would recommend that Emily be paid that incentive.
I'm a little confused. I thought we already approved an incentive for.
Yeah, it is in the budget. He
Yeah.
just felt more comfortable getting a vote on that.
Because
And then
we
it's a modified
actually-
amount. It's
Yeah,
a modified
we're
amount.
changing the amount, smaller amount.
Make a motion.
Second.
I have a motion and a second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. In Emily mentioning the 911 fund, yesterday at the Area Development District meeting, Joe Barras, the head of the state 911 committee, commission, whatever, former state representative, he was supposed to speak for 15 minutes. He spoke for 55 minutes. And talked about, these prepaid cell phones, we're not getting our fair share. I asked again, when were they gonna consider putting the cell rates for 911 the same as land rates? Because if that happens, our problem is solved. And other counties as well. We're not the only ones going through this. I don't think he ever answered the question, did he, Melanie? But he seemed to really want to zero in on those prepaid cell phones. And he called the names, I can't remember, but felt like they were not paying into the fund. Of course, all of the cell phones go to the state. They take a percentage off the top and then rebate back to the counties. Whereas our landline comes to us directly. And I just pointed out, I said, Joe, sure, we can raise our landlines, but the only people that have landlines almost anymore are your senior citizens and your small businesses. I said, and I'm not willing to do that. But if we could just get the cell phone rate up to what the landline rate is, because all the young people are going cell phones now. They really don't want landlines.
Judge, why would they consider increasing the landlines that exist and not the cell phones? That doesn't make any sense because.
He was saying we have that capability
Yeah.
as local units of government. And I said, well, fine and good. Why don't you give us that same option with cell phones? We don't have that option with cell phones, Terry.
Judge,
See, that's been my gripe all along.
did he make any mention of the court case that's going through right now? up
Yes.
in Eastern Kentucky?
Yes,
It's in
yes.
appeals right
'Cause
now.
if that goes through, that will give the county the ability to do that, if I'm not mistaken.
By way of utility as
Well,
a
there's,
fee.
there's two cases, and they're being fought. One is in, Garrett County, and I'll be seeing John tomorrow, or Thursday. I want to ask him, the judge there, about that case. What they're wanting to do is put it on utility bills, but the utility companies are fighting that. So, I don't know where that's gonna go, but I'm watching that, yeah.
It's in the Court of Appeals right now, is it not?
One of
Yeah,
them,
is.
another one's just in circuit court,
Right.
so we'll see what happens. All right. Interfund transfers.
I'm asking for approval to move $500,000 from occupational tax administrator to the general fund. This is just for, regular expenses. And it is a budgeted, already, that amount is budgeted, it's not anything in addition to. I may need to transfer $150,000 into the payroll fund from occupational tax administrator. I'll just be watching that to do what is necessary. And then I do have listed on here the jail fund, however, I did get a payment from the state for state inmates late yesterday, so I won't be needing that $100,000.
Motion to approve the transfer, Judge.
Have a motion, is there a second? Second. Motion and second, all in favor of the motion, say aye.
So we need to
opposed?
modify to 550, I'm sorry, Judge.
Beg your pardon?
550, is that what the total is going to be then?
Yes,
Okay,
maybe, because I may not have to
do payroll.
use all that payroll or, it just depends.
You need that, no. Okay, accounts receivable.
The payroll fund is due $446,158.33 from the sheriff's office for payroll. Like Judge always states that that's just customary.
This is, where we front the sheriff's office, then when the taxes come in, he pays it back. Every county, I don't know of any county that could operate without this type of situation. Sheriff, do you know, will we be, and Tony, you're back there, will we be able to get our tax bills out?
Yeah.
Think we'll have them by October 1st?
Yeah, we will.
Okay, very good. Need a motion to approve the accounts receivable report.
Motion approved.
Have a motion, is there a second?
Second.
Motion second, all in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. All of you have seen, and has Marty already left? The publicity about the Arts Commission property and a cemetery being found there. I don't know where we are at this point. One of the things that,
Judge, I've been in contact with Marty quite a bit on it.
okay,
They're bringing in either archaeologist or anthropologist, I'm not sure what his actual credentials are, but he's got some kind of equipment that can shoot it into the ground and determine how many graves are there, if there's any more than what's been found. There's some people are thinking that one child that was found may be the only one that was left. So they have to do that. And because it's federal grant money, it's kicked in some federal regs that Marty is familiar with, and he's working with that. And then I've also spoken with, talked with Bill Morgan quite a bit about it Sunday, and he's talked with all his family members, and he said that, whatever, as long as it was done in a respectful way, if you want to put a marker up there, or if you wanted to move them, they were going to be fine with that. They weren't going to stand in the way of.
well, I saw the interview with Phil Morgan, Bill's brother, Philip, and Philip was of the opinion that all of the graves had already been moved. He was, he thought that. It would be, if we can determine, have a area cordoned off, put a monument there, a respectful monument with names or whoever, if we can come up with it, and fence that in to be respectful to those family members, rather than have to exhume and rebury. It would appear to me that would be the easiest route to go, but again, I don't know what the law would require.
I think either one would be acceptable,
Okay.
legally and with the family.
Pardon?
Legal, saying either option would probably be acceptable, either moving them or leaving them legally or with the family, so.
Okay, we'll keep the court informed. We do have a couple of personnel items to go over. I would like to ask that we go into executive session
Motion going to executive session.
I just have a
motion.
question. I'm
Yes,
sorry.
I'm
Since
sorry.
it's going to be a little lengthy, could we just finish up? That way anybody that doesn't want to stay will be finished with the last few things, or, I mean, don't you think it's going to be pretty lengthy?
I don't know, I hope not, but it could be, but let's do, we can do that.
Would that be
If
all
that's-
right? Would that be all
nobody
right with y'all? That way if
objects, we'll go
everybody
ahead.
wants to go and doesn't want to
All
stay
right,
for what we do.
let's move into, the judge executive succession plan. You have, this is something that, you have to have 3 people, and I've designated Melanie, Bob, and Larry Jones as a succession plan. This is for emergencies, that if we go into a state of emergency and I'm not available, Melanie is, if Melanie's not, Bob, Health Board member Larry Jones. That's just for your information.
Judge?
Yeah.
Brian's back.
Pardon?
Brian's back.
Brian.
Oh, okay, Brian. What do you think?
All right. I'll just kind of spell out a few of the highlights of these 2 bids. Both of these are dealers of Osage ambulances, which we've dealt with in the past, and the same brand that we bought last year. Very happy with them, good customer service, good product. We couldn't be more pleased. We went with, like I said, we got a bid from ESS out of St. Louis. I've heard of this company, never dealt with them before, so I don't know exactly, how they operate. Their bids were pretty much the same. All the specifications were met. It included the price included the graphicing of the ambulance, also included the stretcher. The warranties, some of the highlights of the warranties, they have a 3-year, 36,000-mile conversion warranty on the ambulance. They have a 6-year, 72,000-mile electrical warranty on all the electrical systems of the ambulance. They have a 10-year, 100,000-mile top and roll cage warranty, a lifetime aluminum module body warranty, and a 5-year, 100,000-mile paint warranty. ESS, the company out of St. Louis, their price was $128,375, and they guaranteed completion in 220 days. The SSV, theirs was $124,285, and theirs included completion within 180 days, so theirs was quite a bit sooner than ESS. So my recommendation, being that we have dealt with SSV before in the past in buying our ambulances, I would recommend going with theirs, because essentially, like I said, all the specifications were met by both companies, and the ESS was roughly around $4,000 higher than the SSV.
So you're saying take the low
Full
bid?
bid.
Sure, yes.
All right, you heard the recommendation, we have a motion, is there a second?
Second.
Motion and second, that we accept the low bid, all in favor of the motion say aye.
Aye.
Any opposed, no, motion carries.
Thank you. It is,
Southern Specialty
make sure I don't say, it's Southeastern Specialty Vehicles, they're out of West Jefferson, North Carolina.
Our animal shelter report. We have, animals in the pen as of 7/31 was 65. Animals brought in by wardens, 23. Animals brought in by citizens, 70. 93 animals taken in, 21 dogs, 10 cats, 23 puppies, 39 kittens. Animals adopted, 72. Animals in foster care, 6. Animals reclaimed, 6. Animals euthanized, 19. Animals in the pen as of 7/31, 51. Adoption fees were $1,635. You've all had an opportunity to review the bills. Do I hear a motion to pay the bills?
Motion to approve payment of the bill.
Motion, is there a second? Motion and second. All in favor of the motion, say aye.
Aye.
Now, Terry, make your motion.
Go executive session.
Have a motion, is there a second?
Second.
We'll be in executive session. We'll call the court back into regular session. We had a discussion this morning with our animal control officers and our shelter director, talking about using the truck that we have, using it more. and trying to get some more communication. The walkie-talkies, I think, Sheriff, that they've got are about wore out, so we're looking at getting some new ones, and we'll be talking to you about it. I guess go through Motorola.
Yeah, they're the ones that we go through, and I
Yeah.
recommend them because they've got good product.
Well, I'll get with you on that and
Okay.
try to, so they have a good handheld.
Right.
The communication in the truck is really good.
Right.
They said. But that don't help them if they go behind the building, there's a Rottweiler.
Right.
About to jump on them, so I guess they need a good handheld, but we'll work on that.
And possibly, and we may have some because we no longer need them, but, and Terry can, give you some insight on this, repeaters. We can put a repeater in the truck. That will help that handheld situation too, but they do need some new ones because they're using our old
Yeah.
analog, but the new analog, the old analog channel is still there, up and running, is good, but I think if we put a repeater system in the truck to where the handheld can hit off of it, then hit
Into
the
the
tower like the mobile unit does, I think that'll clear up all those issues.
Okay.
And I think we may have some repeaters at Motorola that we don't use anymore.
Okay.
Well, I'll get with you and we'll
Okay.
figure that one out. Okay. Any other business come before the court?
Judge, I have one small item. Russell and I were helping one of the neighbors work on some trees along the side of the road, and in digging that up, it couldn't be helped. The operator of the great awl was dipping the stump up, and it pulled the meter from the ground, and when it did, it jerked the meter away from the service going into this man's home. And Russell doesn't have a plumber, so the landowner himself took care of the bill, and I don't have it with me, it was like $100, give or take. I think 105 or 10
Is
bucks.
this a water meter?
To fix the man's line back.
Sure.
And I just wanted to let the court know that, and I'll bring that bill and submit that, but I didn't
Well,
want to
we
do that.
called it, I think we ought to pay it.
Right, I just wanted the court to know that.
Sure.
I'll just give that bill to Emily if that's okay with
Yeah,
everyone.
that's fine.
Okay.
That'll be fine.
I've just got one small thing, Judge. I know y'all are in a hurry. For some time, we've been talking about this today in executive session after one of our employees has turned in a resignation for the shelter. We have a shelter committee in place, but I would like to know what the definition of that committee is from you all. It was my understanding, development of policy and procedure is to be submitted to the fiscal court, those types of things to help organize and help with operational day-to-day duties out there. But if that is not the intent of the court, I kind of wanted to know what you all thought it should be. And possibly, currently it's myself and Jeff and Wendy Baxter, but there's no citizen input on that committee. I'd like to know, as we go through this transition again, how we can kind of help to ensure that things are operationally correct out there. What would you all suggest, and what do you want the definition of that committee to be? And would you be opposed to having another member added that would represent the community?
Well, I think originally the committee, if I recall, I may be wrong, was to, when we changed over to help with the transition, and this was before this current group was there. And we never did, we have some policies, but I don't know if they're defined
Right.
real
right.
good. Let me and Jeff get together with you and the next, between now and the next court meeting
Okay,
and kind of talk about it, work on it.
okay.
And Wendy.
Getting a definition together.
Yeah, get some
Okay.
definitions together of what we expect. Good point. Any other business come before the court? Not, I entertain a motion.
Motion adjourned.
Second.
Meeting adjourned.